of that. This is nothing but the same thing. He files it, on May of 21, 3.5 years later. He, is saying that that judgment should be reviewed. Why? Because it is contrary to NDMC. That's the short point. Identical prayer in a review filed 3.5 years after the Constitution bench is repeated a few weeks before this bench is to convene. With great respect, the Lordship in the Constitution bench doesn't allow these things. What is the review? What is the reference, fellows? Reference is simply one sentence, actually, boils down to. There is a NDMC. NDMC,
there are
9 judges.
Points which I have
Sorry.
But I don't.
And it should be referred. Your Lordship has dealt with NDMC, good, bad, or indifferent, 10 times in the Constitution bench. What your Lordship will do with it is your Lordship prerogative there. You already dealt with NDMC. For that reason, it should be referred to now 9 judges, or maybe 11. Well, with respect, this will be hugely dilatory. Your Lordship has spent all the time. Today, we have gone into the Constitution bench, we've gone into everything.
Lord, it can be anything but dilatory, my Lord. We are dealing with the capital of the nation, my Lord, and therefore, whether it is done today or tomorrow, my Lord, that hardly makes any difference. My learned friend may be in a tremendous hurry to do certain things, my Lord, but we are more on the future course of action, my Lord. We may not be remembered in history for having handed over, my Lord, capital to a complete anarchy.
I don't see.
That's, my Lord, my argument, and I have made those submissions. I'll just, Lord, put it 2-page note.
In his entire 90 page and 54 pages, total of 140-50 pages, no reasons. The representatives of the government of the constituent states may either be members of an All India service or ministers in the Council of Ministers of the constituent states, as may be specified by the governments of the constituent states. Duties and functions of the Joint Cadre Authority. The Joint Cadre Authority shall determine the names of the members of the All India services, shall determine who may be required to serve from time to time in connection with the affairs of each of the constituent states and the period or periods for which their services shall be available to that government. Now, it is common ground that on the Joint Cadre, Delhi sits through its Chief Secretary, as do others. And of course, the central government also sits. Now turn to bookmark 48 at 3992, just a little ahead.
Just 1 second. You said the Delhi's Chief Secretary sits on the...
This is admitted position.
Yes.
Now I'm just showing that document. Obviously, states doesn't mean states. Otherwise, Delhi Chief Secretary can't say.
Page?
3992. It is this notification, not a resolution, which in the past, as a temporary measure, said MHA may do it. The notification is statutory. This will proceed. This will prevail.
Yes.
The central government, in consultation with the government of states concerned, hereby constitutes the Joint Cadre Authority for the IAS, IPS, IFS joint cadres of Arunachal Pradesh, Goa, Mizoram, Union Territories as below. Now, there is, you also may be confused with that line. See, the next line will become clear. Secretary, Ministry of Home Affairs is one of the co-equal persons, representing duties in respect of the Indian Administrative Service and Indian Police Service. 2 is Chief Secretary Arunachal, 3 is Chief Secretary Goa, 4 is Chief Secretary Mizoram, 5 is Chief Secretary Delhi, 6 is Inspector General of so-and-so, then Joint Secretary, etc., etc. Duties are mentioned more than once. Now, some apologies, Manas. 2 paras of yesterday's additional 2-page note, Manas. Because it links to this, the first 2 paras of yesterday's note. Rest of that note is only a quotation from case law, but these 2 paras, Manas, relate to this section.
Which para?
Manas, yesterday I sent you the note.
No, I know. Where is it?
Para 11 of that.
Yes, the allocation of civil.
Allocations. I'm very grateful. This is directly related to this one.
Sorry, Mr. Dr. Singh, just 1 second. Just give me 1 second. What are you reading in that?
May I read the top, the first line
Of
11 of this yesterday's note?
yesterday's note, right?
No. Well, I sent an additional.
Not the one you were reading yesterday, but today's. Okay. Yes, I got it.
Lord, we call it today's note.
I read it in the morning.
Additional rejoinder.
Yes.
Yeah, additional. Call it today's note. So 11 is a
Yes.
top para.
Yes.
My Lord has got it.
Yes.
Allocations of civil service in Agmat cadre is done by the joint cadre authority and not by the Ministry of Home Affairs. Is it continuation of point 3? So I'm sorry, I have to read it like this. The union is arguing that control over allocation to the constituent part of the joint cadre is done by the Ministry of Home Affairs, relying on a resolution of the joint cadre authority in April 89, which Chief Justice just asked me to show. I'll show in a minute. I'll just show in a minute. This is that resolution of 1989. I have shown you notifications, etc. of 95. A mere perusal of the same shows that the Ministry of Home Affairs is merely acting transitionally as a delegate of the Joint Cadre Authority. It says, till such time as the Joint Cadre Authority creates a committee and is no longer the cadre controlling authority. More importantly, this is the second reason. The 89 resolution is before 239AA came into being. Post 239AA is reflected in the 25,495, which my Lord just now saw in a minute ago. It syncs completely, it fits in and harmoniously, where Delhi is represented in the authority by its chief secretary, similar to the full-fledged states of Arunachal Pradesh, etc., etc. Then this para 12 is the addition, which is why I have to file this. Very important. Very, very important. That a civil services board exists in the NCT of Delhi to advise on transfers and postings within NCT Delhi. This is vital. The existence of a civil services board in Delhi, in fact, shows that Delhi has been treated at par with the state and not a union territory which is not going to be enjoying any benefit of a state. The IAS Cadre Amendment Rules of 2014, I'm sorry.
Yes.
Now, your Lordship remembers he cited TSR Subramanian. Post the judgment of Subramanian, there is an amendment to Rule 7. This is vital. It is in the bookmark, but I'll read it from here. It's quoted. Actually, I'm sorry. The entire picture is not there. So may I take your Lordships to these two documents, not read from here, because I'm not quoting the whole thing. So would my Lords first see the resolution Mr. Mehta relied upon in CV4, page 138. And then this Rule 7 amendment. Convenience, volume 4, the relevant page is 138.
Convenience, there were 3 convenience volumes.
No, there was a final. It's called a final compilation, which your Lordship should call 4 actually.
What is the PDF page?
Page is 138. I'm sorry, it may be 140 PDF page.
Not 138. 138 is something else.
140 maybe 140.
Just 1 second.
It's bookmark 7. It's titled as Functions to Remain with the MHT.
138.
138 is correct. I thought your Lordship may have a 2-page.
That functions
I'm grateful.
functions to remain with MHA, UT division.
This is Narasimha has got
138.
Chief Justice has it.
Yes.
I'm sorry, Dr. Singh, we just.
No. Please take your time. It's 138.
It's 142 of PDF, huh? Volume 4.
What is the title of this?
Volume 4, 142.
It says Final Compilation 4.
It's actually minutes of meeting.
Filed by Mr. Mehta.
It's a notification, no?
Yeah.
25,495.
Yes.
No, that my Lord has seen.
No.
I'm now taking your Lordship to the document filed by Mr. Mehta, relying on a resolution of 1989.
All right. That is one.
Part-
Yes. My brother is right. It's a minute.
That is Justice Kohli may not have found it. It is
139, no, Hima? 139 there. Volume 4, 139.
compilation 4 of Final Compilation 4.
I'll look for it. Will you please, I'll not detail the rest. Please go ahead.
पहले दिन का
Little important, perhaps you should
पहले दिन
share
का
with
जो
Justice
4
Shah's.
volumes
4 lines to be read, 6 lines. Functions to remain within, please mark the date, 1989 and a resolution, not a statutory notification. Note these 2 points. It's 1989 and a resolution. Functions to remain with the MHA UT division. Transfer posting of cadre officers from one segment to another. However, for this purpose, joint cadre authority will frame proper guidelines, keeping the overall interest of the service officers as well as the constituent state constituent units in view. Till the new guidelines are framed by the joint cadre authority, transfer posting from one segment to another will be guided by the guidelines as existing on date. This is 89, then comes 92, your lordships 239 AA, then comes the statutory notification in 95. And the language of this itself is till such time.
Yes.
Now, the second item is amendment to Rule 7, which is at
Part 5 at page 1.
same compilation, bookmark 5 at page 131.
So this was October 1989.
Correct.
Then what is the date of the joint cadre rules which you showed us?
That is 74. That is
joint cadre rules.
the rule or the notification.
The rules.
Oh no, rules.
The notification.
Just so that we can put it here.
25th of April 1995.
Right, that's the notification, statutory notification.
And the joint cadre rules of page 3949, what is the date of those?
1972. Correct.
That is 1972.
That is a general joint cadre rule, pre-existing one.
Cadre rules.
There before that. Now, my lords will kindly come to the amendment to Rule 7 in the context of Subramaniam also, which was cited at 131 of the same 4th compilation. Bookmark 5.
The notification of 2014.
Yes. Correct.
20th January.
131.
Yes.
This is important, the source of power and energy. In exercise of the powers, so again, same statutory source. In exercise of the powers conferred by 3(1) of the All India Services Act, which my lord has read with me, the central government, in consultation with the governments of the states concerned, hereby makes the following rules further to amend the rules, the cadre rules of 1954, which my lord just asked me.
Yes.
These rules may be called the IAS Cadre Amendment Rules of 2014. If your lordship will come to 2A, just under this, 2 lines below this. In the Administrative Service Cadre Rules of 54, for Rule 7, the following shall be substituted. Postings. All appointments of cadre officers shall be made on the recommendation of the Civil Services Board as specified in the schedule annexed to these rules. All appointments to cadre posts referred to in Sub-Rule 1 shall be made in the case of a state cadre by the state government. In the case of a joint cadre by the state government concerned. Then kindly see how they understand the word state. Kindly go on. Just like the earlier rules, but state is the only word used. UT is not used, but they understand it to include UT. Then, may I, with your lordship permission, skip 3, 4, 5 and 7A. May I skip that? Kindly come below 7A, just the next page. For the schedule, the following schedule shall be substituted. Schedule. Composition of Civil Services Board. Every state government shall constitute a Civil Services Board which shall consist of Chief Secretary, Chairman, Senior Most Additional Chief Secretary, Board Revenue, Financial Commissioner, etc. rank, Member, Principal Secretary, Department of Personnel, Member Secretary. The Civil Services Board shall make recommendation for all appointment of cadre officers. This is the Civil Services Board functioning in Delhi. Where does it come from for a union territory if you read the state technically? The Civil Services Board shall examine the cases of officers who are proposed to be transferred before completion of minimum period. They have always understood the UT to be included in all these rules, even though the word state is mentioned. They are having a Civil Services Board. It's a different matter that he excises the power and doesn't allow me to excise. But the Civil Services Board is here.
Just technically, I read this yesterday.
That's all right. I'm giving
I
a
read,
submission.
it's not as if this was.
I'm not saying you suppressed it. I'm saying
Yes,
I'm
yes,
giving an
I read
interpretation.
it.
Just the proviso of clause 5, it's an advisory body.
Of course, Balu, the Civil Services Board, like everything else, is an advisory body. It makes suggestions. The government can always, Balu, accept. This covers my para 11.
LG,
Yeah.
that was my submission.
No, that obviously advises the LG or these in-city government, but it will be a later issue. Now, I have done with this point, and in order to come back to yesterday's rejoinder. So these are the 2 points related to para 3. I'm sorry, Manu, the Lordship may make a mark in para 3 of the yesterday's submission that they should be read with 11 and 12, which my Lord has just read. I now come to my yesterday's rejoinder note to para 4.
Yes.
Now your Lordship asked me that question on 309. Yesterday I said, well, I answered it, but I said I will be coming to it later in the note.
Yesterday's note.
Yesterday's note, para 4.
Scope of entry. What is
Correct. Scope of entry 41, list 2 is wider than the scope of the proviso to Article 309, and any executive action under 309 does not limit the power of the legislature to make laws under entry 41, list 2. That's the head proposition. Before I read that, may I itemize the points here? It will be easier than reading, then I'll read only one part. The points which I said yesterday need to be itemized now. A. I'm repeating, but I'm itemizing it under this section. The Constitution. 309 starts with subject to the whole Constitution. And necessarily, Malus, our special part dealing with 239 AA, etc., is part of that Constitution. And 309 is subject to that, to the entire Constitution. It says subject to this Constitution.
239 also says subject to
No,
Constitution.
it says in only one clause. Not in
A.
I checked. 3A. Only in 3A. That's the point. My Lord is right.
Yeah.
Of 309, subject to the provisions of this Constitution, comma, acts of the appropriate legislature, etc.
Right.
So it's even acts, subject to. Second, B. Prem Kumar Jain was a direct case in the same part, 14, same chapter 1. 3 sections apart in 312. 3 sections apart. C.
Yes.
For 312, 4 learned judges of this court, which has stood the test of time, held that UT is covered and subsumed. In that case, the UT of Himachal and Delhi were held to form a joint cadre reversing the High Court, which said because they are UTs, they are not covered under the word state. So, Malus, the C point is that it has been already decided by your lordships that UT is covered, albeit in a case arising under 312. D. Absent, Malus, any special provision of this chapter or this part, your lordship will never read 312 to include UTs and 309 not to include UTs. As simple as that. As legislative power. It would be a very startling result unless your Lordship were forced by some language to do it.
312 to
D is, I've dealt with C, which is for 312. Absent specific exclusionary language in the Constitution in this chapter, your Lordship will never read UTs to be subsumed under 312 as Jain holds, and UTs not to apply to 309 as my learned friend, the solicitor, argues. Imagine the startling consequences of that kind of interpretation. So now I come to the speed. They are the 4 points which are not put in this form. So, Lordship is kind enough to do it. Now, Lordship, read EF from this 2 paras only, from this note. That can be E and F of your Lordship. So, EF and G in continuation, same section. This is on the width of entry 41 being larger than 309. Para 4. I. As far as the Agbert cadre for IAS and Danics are concerned, the power in respect of them relates to entry 70. And even there, as per applicable rules, the power to post and transfer within the government of NCT has been given to the elected government as per the rules. Thus, the rules have been framed with reference to 70 and do not have any impact in respect of entry 41. Now, this is the proposition I want to place double I. In any event, it is settled law that scope of directly covered, scope of 41 is broader than the power to frame rules under 309. The underlying basis of my learned friend's argument is that I can make rules under 309, therefore I can get out of 41. 41 dollars, kindly see. The Supreme Court, again ironically 4 learned judges. Justice Sarkaria speaking for 4 learned judges in Saxena's case. It is sufficient to read from here. 1976, 4 HCC 750, the bookmark is given there, need not go there. Para 32. It is well settled that entries in these legislative lists in Schedule 7 are to be construed in their widest possible amplitude, and each general word used in such entries must be held to comprehend ancillary or subsidiary matters. Thus, considered, it is clear from the scope of 41, there is some typo there, it should be that the scope, is wider than the matter of regulating the recruitment and conditions of services of public service under 309. This is enough because I submit from my point of view. The area of legislative competence, defined by entry 41 is far more comprehensive than that covered by the provisions of 309. By virtue of Articles 246, 309 read with entry 41 list 2, therefore the state legislature had legislative competence not only to change the service condition of state civil servants with retrospective effect, but also to validate with retroactive force invalid executive orders retiring the service, because such validating legislation must be regarded as subsidiary or auxiliary to the power of legislation of the subject government. Clearly, Manas, they have held. Next paragraph. As such, merely because rules may have been made by the President under the provision of 309, as indeed for Danics also, does not mean that the competence of NCT Assembly under entry 41 becomes displaced or vanishes. Unless your Lordship holds that 309 excludes all UTs. That's a different matter. Also note, Malus, the last point under this section is a proviso of 309, which is not so frequently noticed. I want to just emphasize the last 3 lines of that proviso as we end this section. 309 kindly come. They'll be also very important for legislatures like the UT or somebody else exercising legislative power. That's why 309 proviso is important. May I read for focus just the 4 lines and then I'll read the whole article. I'm not trying to avoid this. Just for focus, I'll read the 4 lines first. Just come to the very end of 309, the 4th last line. And the conditions of service of persons appointed to such services and posts until provision in that behalf is made by or under an act of the appropriate legislature under this article. An appropriate legislature will include a UT legislature. And any rules so made shall have effect subject to the provision of such act. So 309 defers provisionally to the ultimate enactment by the legislature. Now read the whole article. Subject to the provision of this constitution, acts of the appropriate legislature, again the same phrase, acts of the appropriate legislature, may regulate the recruitment and conditions of service of persons appointed to public services and posts in connection with the affairs of the union or of any state, provided it shall be competent for the president or such person as he may direct in the case of services and posts in connection with the affairs of the union, and for the governor of a state or such person as he may direct in the case of services and posts in connection with the affairs of the state, to make rules regulating the recruitment and the conditions of service of persons appointed to such services and posts until, that's the operative word from my perspective, provision in that behalf is made by or under an act of the appropriate legislature, etc. Well, this completes this section. I now go, Malas, to para 5. In respect of All India services, the statutory rules framed under the All India Services Act of 1951 will trump an executive notification issued by the central government, including the impugn notification. Impugn notification is purely executive letter. And the statutory rules clearly indicate that state shall include union territory. Rule 46(1) of the Transaction of Business Rules relied upon. Well, this a lot of time was spent. My short answer is Transaction of Business Rules is once you have something, how you allocate amongst that. It has no relevance to what you have or may not have. Rule 46 of the TBR makes it clear that with respect to persons serving in Delhi administration, the LG has to follow either the statutory rules framed in respect of services or has to follow any other presidential order and consult the Chief Minister if the order so provides under 239. The impugn notification, impugn in this case of 2015, in addition to seeking to exclude entry 41 from the legislative and executive care of the Delhi Assembly, purports to delegate certain powers of the central government to the HG. As per settled law, this will be subject to the extant rules already framed by the central government. What are those rules? In respect to the All India Services Rules, Parliament has enacted a law, and the central government has framed statutory rules under the power granted to it under 3(1) of the Act. Now, this Act is important. This is something else I just showed in a minute. 820, which my Lord has seen, and bookmark 43 is the rules. 820 is the same 820, which your Lordship saw just now in the morning. Rule 21C of the IAS cadre rules, these rules, which your Lordship has had in the previous slide, define state as including UT. The rules clearly indicate, should have been 21C. The rules clearly indicate that once an officer is allocated to a particular state UT, transfers, postings within the state shall be the responsibility of the respective state UT. Well, as your Lordship saw with me, para 41 to 46 of my opening submissions. I have quoted and relied on that rule. Rule 7, my Lord remembers, and 11A. My Lord remembers 7 and 11A. Those are those 41 to 46. I can show it or I can save time by reminding your Lordship of 41, 46. It will save time. 7 and 11A are vital. They are dispositive in my humble and respectful submission. They are saying clearly that I shall be responsible. So let us kindly take 41 to 46 as read, and what is the quotation there of Rule 7 and 11A in particular. Further, it is settled law that statutory rules will trump an executive notification, which is the impugned notification. As such, the impugned notification clearly derogates from the statutory rules under the All India Services Act, which give power to transfer and posting in respect of Agmut and Danix to the elected government of NCT. The Supreme Court has reiterated this position and summarized the law. Well, as your Lordship's judgment, paras are given. The impugned notification, I say, is liable to be struck down. Now, this, I believe, is a loose judgment which will be handed over, is not in the compilation. It's given over already. Your Lordship may note the paras. It clearly says, it's obvious proposition, that they in service matters, they have to give way to the Act and the rules. That's what your Lordship says here. And the relevant para in particular is well as 16, 17. Just to shorten the paras, especially 16, 17, it's well as a division bench authored by my Lord Justice Chief Justice. There is a small minor point before I come to the last part of the submissions. This is about Balakrishnan. This we've done and dusted. We are not going to. Just note that para 6. Rejection of the Balakrishnan report has otherwise elsewhere been accepted by my learned friend. If I may say so, somewhat unwittingly, because that never came up. In the application, for reference 19006/22, in para 63, he says that the majority has rejected Balakrishnan. I'm just leaving it. Not that it's going to be a.
But I didn't accept. I read paragraph from the majority and your Lordship that it is relied upon.
No, sir. I am saying something very different.
I didn't accept.
Your IA says in para 63, I'm only pointing that out. What it says, you can't change, I can't change. Affidavit given by your officer makes it very clear that the 2018 Constitution Bench rejected the Balakrishnan report. Now, it's covered. Last 3 minutes now. Come to my today's note, the new additional rejoinder note. I made this submission, but we got the wrong citation yesterday towards the end of the day, so I've just quoted it. The point is, before your Lordship goes into para 14 of my today's note, the additional rejoinder note. The point before that is important.
Which one?
Whereas now I am coming to my today's note, the additional rejoinder note, para 14.
Para 14.
आज का जो additional
Mr. Shah has got it. Title is in the context of the NCT.
So the additional rejoinder point, I have only para 12, up to para 12. Maybe mistakenly not.
14 is there.
Yeah, it's there at page 3.
Just I'm not raising any objection. I'll take a copy. The copy I received here ends at para 12.
My lords have got it wrong.
No, on
Here.
I have got only up to para 12.
Well, that's what I also got up to para. Therefore, I just.
My deepest apology.
Now, hard copy I have got it.
This is vital for me. I don't know how your lordship. One Senate teacher's got to learn. Give a copy now.
The morning, so maybe by.
No, it is only there. Up to para 12. Anyway, I have got it.
My apologies.
It's okay.
I'll send your lordship. The other one is already there.
Please do. Yeah.
Actually, Dr. Singhvi, you can read this para. I was also reflecting on it last night. See, the entirety of list 2, there's a legal fiction which we have to, as we always say, you shouldn't allow your mind to boggle. There is a legal fiction. There's a legal fiction in 239AA, as a result of which the entirety of list 2 of the 7th schedule is basically a concurrent power.
Is made like a concurrent.
Is made like a concurrent power in relation to the UT of Delhi. So Parliament can legislate on the entirety of list 2.
Just like the state can also, or the UT can
Right?
also.
So that's the effect of it. Now, if Parliament can legislate with the entirety of list 2 in addition to list 1 and list 3, then Parliament has the power to legislate under entry 41 of list 2 also. Now, if Parliament has the legislative power on entry 41 of list 2, then there is no reason to take recourse to entry 97. You take
That's the short point I am making.
you take recourse to entry 97 and article 248, which
Not
is residuary power, where there is no provision elsewhere.
Very great respect, but I can't put it more pithily.
Because both the judgment in Dillon's case,
Which is
has been
cited in the
followed,
case I
which was
quoted.
followed in
Dillon is cited.
Amritlal's case here, it says that in deciding as to whether Parliament has legislative competence, you ask yourself only one question. Is there any entry in list 2 which covers the field? If there is an entry in list 2, then Parliament has no legislative
respect.
power.
That is that.
If there is no entry in list 2, then Parliament has to have power either under list 1 or list 3 or entry 97. That's Dillon. That's the residual power.
That's right.
But here, Parliament undoubtedly has powers on entry 41 of list 2 because of the
It's a
fact
concurrent
that
list.
it's power.
It's a and therefore, just it will take less than 2 minutes. What your lordship has put, very interesting, Dillon, from two perspectives. One the negative, one the positive. I've given two cases. Just give me 2 minutes of that. I've missed out para 13, which I'll come to after. Just come to 14 first.
Yes.
Just, it's one para each, your lordship need not go to the judgment. Just read from here. Be that as it may, I'm straight away coming. This is the reverse. In my favor, but in the reverse context. Just read it. In my favor, reverse context. Be that as it may, it is not necessary to pursue this line of reasoning since we are in total agreement with the approach evolved in Dillon. A decision by a constitutional bench of 7 judges, the test evolved in the said decision is where the competence of Parliament to enact a particular statute is questioned, comma, exactly what my Lord Chief Justice said. One must look at the several entries in list 2 to find out, applying the well-known principles in this behalf, including expansive reading, whether the said statute is relatable to any of those entries. If the statute does not relate to any of the entries in list 2, no further inquiry is necessary. That's why it's a reverse context. It must be held that Parliament is competent to enact a statute, whether by list 1, list 3 or 97. Now read the next sentence. In this case, it is not even suggested that either of the two enactments in question are relatable to any entry in list 2. The opposite of my case. There cannot be an entry clearer than 41 on the subject we are discussing. Now see, Malas, the recent judgment to which my Lord Justice Shah was a party in the reverse direction, holding just the opposite, in my favor again, but in the context is reverse. This is 2022, Malas, citation is given there. But the question is whether, while interpreting entry 40 of list 1, alongside 34 and 62 of list 2, power to tax lotteries organized by the Government of India or the government of a state is also taken away from entry 62 of list 2 and is to be read within the ambit of entry 40 of list 1. And therefore, the states of Karnataka and Kerala in the instant cases had no competence to enact the include acts. We have already stated that only lotteries organized by the government of India or the government of a state is carved out of the subject betting and gambling in list 2. Entry 34 is list 2 months. Carved out of betting and gambling in entry 34 list 2 and is placed in entry 40, only that part. Entry 62, inter alia speaks of tax on betting and gambling. But that we do not think by that the state legislature has been denuded of their power to levy tax under 62 of list 2 on lotteries organized by the government of India or the government of state. We say so for the following reasons. Now, sixth reason. Entry 97 can be invoked only when any matter is not enumerated in list 2 or list 3. It's in the affirmative, in the other direction. Including any tax not mentioned in the said lists. There is no specific entry for levy of tax on betting and gambling in list 1. That's why entry 97 can't come in. It is only in entry 62, then your lordship goes on. I don't want to read the whole of it. So, this is clearly settled. Last point, before I end, para 13, the para just above this. That's all. Well, it's para 30, 1-3. I have said it orally many times. I put it in writing. Something in his favor. I've already said it many times.
Para 3.
1-3.
1-3. Of
Just the
yesterday.
preceding para of what
Oh,
I've just
okay.
immediately preceding. And that is why, Manoj, the issue is a very narrow one. It doesn't actually, should not cause any heartburn to anybody. Kindly see this. The scheme of 239AA provides adequate checks and balances for protection of national interests in the NCT of Delhi. This has been repeated, Manoj, so many times. Capital NCT Delhi. Look at this, Manoj. The Constitution provides. What more protection can Lordship give than give Parliament the entire list too as a concurrent list? Can a Lordship give any more protection, Manoj? The boss is Parliament, if I may use colloquial words, Manoj. Nobody is denying that. The issue is absent Parliament exercising contrary power, contrary legislative power. Somebody in the concurrent list can't exercise the same power, in this case a UT. That's the issue. Now read this. A conjoint reading of 239AA 3 and 4 posits that the conscious scheme adopted by Parliament in exercise of its constituent power, that is by constitutional amendment, is that the legislative power and concomitant coextensive executive power of the NCT, obviously not concerned with those 6 entries, can be legislatively overridden by Parliament. It's as simple as that. All this was national security, capital of India, nothing. Parliament needs to make a law or an existing law needs to be applied to trump the exercise of power by the Assembly of NCT. I am saying this. He is not saying it, I am saying it. With deepest humility, Minister. Your Lordship is given a picture as if somebody is hijacking the national capital. Then, if we are seeking to obliterate, now this is very important, this is a nuance, it's a jurisprudential nuance which I am submitting for Lordship's kind consideration. There is a difference between Parliament and the central government. My problem is my learned friend is reading Parliament to be the central government. That is my problem. That is where the nub of the problem arises. Parliament, your Lordship, is given power to trump everything. He says central government should trump. What is happening in this case? The notification impugned is a central government notification. That is not Parliament. Please exercise your parliamentary power. The Union is seeking to obliterate the distinction between Parliament and central government. Under the present scheme, the Assembly of NCT has full play in any unoccupied field of an entry in List 2. Acceptance of the Union argument and upholding of the impugned notification would effectively endow the Union government with an executive override. Your Lordship gives him parliamentary override. He gives to himself executive override by the impugned notification, which I have said is nothing more than adding 41 to 1, 2 and 18 by executive order. That's the simple nub of this case. Endow the Union government with an executive override over the Assembly of NCT. This is clearly opposed to the fundamental scheme of 239AA. It must be borne in mind that both legislative and executive checks that govern the exercise of power. 1. The entire list 2 for NCT effectively works as a concurrent list. Exactly what my Lord just observed. I am saying so myself. And this, well, I say what I am saying is, of course, subject to my Lord's, harmonizes the whole thing. What he says, well, will create a discordance. Because executive override of Parliament, of central government, can never be envisaged with a parliamentary override. The entire list for the NCT effectively works as a concurrent list. If any law made by Assembly is in conflict with a parliamentary law, the same can be reserved for consideration of the President. That's another Lordship knows concurrent list procedures. Further, in terms of the functioning of the executive, there's a difference power to refer. That's a separate one. Let's not get into it. Well, I only remains for me to thank your Lordships for a very patient hearing for both of us. Respect constraints. May I end, Malas, in pre-independence times, Malas. Long before independence, Malas. The British still used to call it the Indian Civil Service. So Nehru made a very interesting comment. He says, it is neither Indian, nor civil, nor a service.
At that time.
Well, my submission is that at the end of this case, it is vital for your Lordships to demarcate black and white the powers. Otherwise, well, it will be either less of a service or less of civil. It will remain Indian. Deeply obliged.
Thank you.
My lord, immensely, my lord, for more than patient hearing.
Thank you, Mr.
We are
President.
immensely
I
grateful to
only-
all your.
I've done it within 1 hour, Manoj. I want to repeat that.
No, you can
Get
absolutely.
some
were
brownie
down to
points
1 hour.
for this.
It was a learning experience, my lord.
Thank you, Mr. Solicitor. Thank you,
Right.
Dr. Singh.
Thank you, everyone.
Very deeply obliged.
We'll take the mentioning.
Yes.